Authority versus Linden Housing Corporation, UNNL 852-25. Plains Council, can I have your appearance, please?
Good morning, Your Honor. Raven Hamlin for the firm of Hunter and River.
Councilor defendant. Thank you. Sorry.
Good morning, Your Honor. Clerk will agree to for 11 and for the
All right, please be seated. We're here on we've had several occasions to come together. We've had several occasions where the court has required status letters. The matter presents as a order to show cause seeking certain relief defined in the pleading, and no new supplemental request for relief has been filed in this action. An answer was filed by the defendant refuting or at least addressing the fact of the alleged ineffective, inappropriate, non-binding meeting that was held, but in demonstrating in the papers that a meeting was subsequently conducted to address at a special meeting on March 20th, 2025, the issues with respect to the termination of the agreement. That's all in the record from the papers. That was basically the relief sought in the complaint, was whether or not this was a proper termination of an agreement. I'll hear counsel for the plaintiff, but we're limited to the papers filed, and I have to say for the record, this was filed on March 3rd. It was promptly set down for a return date. We've had several return dates with sometimes people appearing, sometimes people not appearing, and the court holding this matter open because it related to matters of pseudo-public interest relating to the housings of where persons of Union County residents or persons whatever live, and the court being reluctant to grant relief that might impact that without everyone having an opportunity to further address the what if or what happens next aspects, which are all not part of the scope of this verified complaint. And it continued for some time, and an examination of the ACMS will reveal many correspondence reporting on attempted, pending theories on how a resolution of how the terminated agreement could still continue with relationships and issues being addressed, such as services to be provided going forward, amounts of payments to be made going from the past. That is all not part of the verified complaint seeking relief. But we continued it, and the court would do it again, because if this courtroom can be a forum for helping to resolve a matter, that's the best result, is when the parties do it themselves. Because when a judge makes a decision, he may believe it's fair and just, and it is. And it's subject to be reviewed by the appellate division. But when the parties come to a decision, they've brokered it, they've measured it, and they've agreed to it. They've said, I'll give and I'll take, and you walk away shaking hands with a resolution that you can all live with because you built it. Counsel, has that happened, or am I proceeding with making a decision which has been discussed on the record numerous times about, and I think the court even bluntly described the status as defendant did a do-over meeting. And the do-over meeting accomplished the due process and the compliance with all controlling rules, ordinances, regulations, statutes, case law. So why we didn't simply make that decision when that was first brought to the attention is the court's fault. Because I attempted to help enable you to stay together because this docket stayed open, so that the important issue of housing be addressed. And it's not a coincidence. I'm the Mount Laurel judge also. So I hear these kinds of matters. And I hear matters relating to low-income, middle-income housing, which is what's in play here. It doesn't offend me. It concerns me. Because it's in the scope of the hat that I wear in those kind of cases. And they have strict time deadlines. The city of Linden, as far as I know, is fully compliant with their deadlines on all those matters, in case anyone wants to know. But there are certain deadlines coming up at the end of June and at the end of August that are seriously being strictly enforced. So me knowing that, I have a hard time hearing this concept of housing and simply cutting it to the wind and hoping that everything could be just fine. So I'm asking for a status from counsel who got here early, who had more opportunity to meet and confer and to attempt to address issues, is what's the status, plaintiff, what's the status of your case? Do you still seek application from the court to address your verified complaint on the return date, which is now being continued again till today? It's your case, it's your right. How do you wish the court to proceed, please?
We've come to a resolution.
Outstanding, hallelujah. Do you wish to put that on the record, or do I dismiss the case? And having been the judge of so many matters where we say we're resolved and we don't put it on the record, I always regret that. But I say you don't have to put it on the record. Person A, send a text to person B about what it is. Person B, when you receive it, say, I agree, and send. Person A, say you received the text or email successfully, then both you look at me, put your thumbs up, and I'll say, I at least have a record as between gentlemen and great lawyers that this is not going to be coming back to me on, we didn't agree fully, we need to have a hearing on what we agreed on. So, are we resolved, Count? I expect and I'm confident with the great lawyers that are here that that has happened. Is that right, plaintiff?
We are.
Is there anything I could do to provide a record for you to put that on the record?
I think it would be helpful to put it on the record, just unless council disagrees.
Well, we have,
The
the
general
were
terms.
writing,
It's in
both
writing,
sides
yes.
have agreed to, and
It's plaintiff's case. I'm abide plaintiff's request if he wishes to put it on the record, but I have to be sensitive to matters which clients may have as sensitive, but it's a public courtroom and counsel's case. Counsel,
Yeah, so
as you
just
see fit, go ahead.
The salient terms are that the parties are going to agree within the next 10 days to meet. That's gonna be part of this transition period. In that 10 days, the parties will determine which, if any, employees of the Linden Housing Authority will be provided to the Linden Housing Corporation. In addition, any services that are needed by the Linden Housing Corporation, the Linden Housing Authority, and the corporation will meet to make that determination. It is agreed that the Linden Housing Corporation will continue to compensate those employees that are providing services and pay for those services within that 10-day period. If after the 10-day period there's no agreement, whatever terms remain outstanding, the parties agree to submit to arbitration mediation, which will be binding. The agreement as between the parties will terminate as of August the 1st of 2025. There's an outstanding claim for monies owed to the Linden Housing Authority in the amount of approximately $258,000, of which the Linden Housing Corporation will pay that amount, an amount of $108,000 approximately, and the balance to be determined either through the parties as to what will be owed. If they can't come to an agreement, that too will be submitted to this binding mediation. That a check will be sent to me or be delivered to my office by tomorrow. In addition, the Housing Authority.
Is there an amount of the check that you need to be covered, or is it
Yeah,
in the agreement?
it's in the agreement.
Okay.
Yeah, that's $108,533.90. The remaining $150,000 balance will be the subject of this discussion through the transition meeting, as well as whether or not it needs to be submitted to mediation. The Linden Housing Authority will also contact a vendor known as PHA Web to authorize PHA Web to access and transfer all data or information related to the Linden Housing Corporation only to the Linden Housing Corporation so that they can establish their own account at PHA Web because they don't have access. Currently, their access is through us, so PHA Web take their information, give it to the Linden Housing Corporation. There's remaining two other issues. One is that there's certain property that's belonging to the Linden Housing Authority that is contained in an email that I submitted to council with attachments. He's aware of what that is. The Linden Housing Corporation will endeavor to provide those documents, that information, with tangible, intangible. We have items that the Linden Housing Corporation indicates that they need from us. There's key fobs, there's access to buildings that we will provide. And if there's any dispute, once again, of the remaining items, where are they? How do we get them? That too will be the subject of this binding mediation. And then that would, I believe, resolve everything.
Council, that fairly addressed your understanding?
Yes, Chairman, in fact, we spelled it all out here. The only thing I would see that Mr. Hamlin's recitation is complete and accurate. The intent of the payment that's being made tomorrow is Mr. Hamlin will hold that in trust until the verification that the Housing Authority has done a couple of things that need to be done immediately. One, Mr. Hamlin mentioned, is reaching out to the vendor for PHA Web to give that vendor authorization to work with the Housing Corporation.
So does reaching out trigger right to be paid, or does completing that service so that we're not
Just
unclear?
reaching out, is also right. And with that, the other thing that would be required for the release of the money that's to be delivered tomorrow would be the actual physical delivery of the key fobs and the master keys and the access codes.
And that's for the LHC properties.
Yes, which should be as simple as someone physically handing that to someone else.
Okay, and as I always said, for 17 months on land or tenant court, you get a receipt when you turn the keys in, and everybody's phone is an automatic database. You take a picture of the receipt so that everybody knows what's happened and it's in writing, so that the return of all the key fobs can be demonstrated. Take a picture of all the key fobs if you wish, so that there's nothing further. I don't wish any further issues to be having to be brought up by counsel, who are great lawyers, who have other cases, and it seems like you've got this wrapped up very well, and I'm really proud of how well you worked together on this. It was hard, it took a lot of twisting, but I will say the theme of this isn't do-over. The theme of this is we're better together, because the demonstration that the court has seen by the fact that the severance may have taken place, you still needed each other. And I think that long historical relationship of how things started back in the beginning, which were so brought out well by plaintiff's papers, I would never have known any of that history if you hadn't included it. It wasn't for nothing that you did all that work, counsel. That's a relationship that started long ago, and the need for that to continue is best known by you guys, how much further that should happen and to what extent, under what terms. But sometimes we're better together, and continuing forward under new terms makes better sense than going to look for somebody else to do something that someone already knows very well how to do. And the need for that to be continuous, as we said on the first day, continue flawless, uninterrupted, because housing has to not be an uncertainty for people. People can't be wondering, what's going on with these guys? Am I going to be living here any further? And we cannot risk that. And I'm so confident that the way you guys have handled this has seamlessly delivered that since we last saw each other to anyone that's living in those housings, anyone subject to this, because people know things are going on or that something's just not the same. And now they can all go to sleep at night, so to speak, and actually, knowing that you guys have addressed this and that everything is going to be fine, and they're going to be on notice properly if anything changes, so that everyone's housing can be appropriately addressed. And that's the key, and that's what you're working on here, is getting people paid who help provide those services, is getting the key fobs transferred so that we can have a flawless, continuous opportunity for housing presented, which is what the whole purpose of this beginning and what each of your entities have served so well and continue to do. Really proud of what you did, guys. Really, really proud of you. To the extent that matters. I saw what it took, and it was very hard what you did, and you stuck with it, and you wrestled it down, and you both won. I'm really proud of you. Your clients should be proud of the selection of lawyers that they have.
Thank you. May I say that we appreciate, I know I'm speaking here for Mr. Hamlin as well, we absolutely appreciate the court's patience through this, and more importantly, your direction, because it was the court's direction, most specifically, the last time we were in front of Your Honor, I think they got this across the finish line.
We do what we need to do, but it's always better when we have great lawyers that work it. Thank you. Thank you. Have a great time. Have a great weekend. Be safe. Enjoy your extra day. And remember why we have a holiday.
Thank you.
Thank you.
That's your thing. It's on my office.